Good evening, all. Buenas noches and bienvenidos. I am Patria Frias Colon, a justice of the New York State Supreme Court civil term in Kings County. Tonight, I have the distinct pleasure to welcome all of you, 300 virtually and over 180 in person. Thank you for interrupting your dinner time to be with us on this historic 76th anniversary of a case that many of us had not heard of, Mendez versus Westminster. Latinos have made indelible contributions to the civil rights movement throughout American history. And there are court cases that prove this, cases that have influenced the human experience in the United States. While several of these cases have been an integral part of history, many aren't known to us, but which nonetheless have had lasting impact. Tonight, we highlight one of those many cases. Here with me tonight are your moderators for this evening, New York State Court of Claims judges, Javier E. Vargas and Linda Mejias Glover. We are truly delighted to welcome all of you to this evening's program, the production of Mendez versus Westminster, a reenactment. This year marks the 76th anniversary of this vitally important case in our nation's jurisprudence. You might ask, what's the big deal about this case? Well, it's only one of the most important precedents toward the desegregation of public schools and other public spaces in our country. It predates Brown versus Board of Education, and the critical role Mendez versus Westminster played in setting the stage for the United States Supreme Court's reversal of the separate but equal doctrine simply cannot be overstated. I want to extend our thanks and gratitude for the support of our friends and co-sponsors, including the Asian American Judges Association of New York and their president, Shahabuddin Ali, a supervising judge of the New York Civil Court in New York County. Also, Judicial Friends Association and their president, Verna L. Saunders, Justice of the New York State Supreme Court, civil term, New York County. The Columbia Law School team, with the incredible support from Dean Andrea Saavedra, as well as the St. John's Law School team, with incredible support from Professor Christine Lázaro. The Judicial Institute and the Historical Society of New York Courts for their amazing support and teamwork, including updating our program website with great resources for all of you from our 2021 and for this evening's program. Their collaboration ensured that everyone who registered could log on with ease. And of course, the Franklin H. Williams Judicial Commission, and to the Latino Judges Association Mendez Committee. Thank you for your tireless work and dedication in making tonight a resound success. You make us proud. I want to personally thank these judges who said presente and joined this ever-working committee, the chair of the Latino Judges Association's CLE Committee, Honorable John Howard Algarin from the Bronx County Civil Court, the Honorable Lourdes M. Ventura of Queens Supreme Court Civil Term, the Honorable Javier E. Vargas, Court of Claims serving in New York County, the Honorable Linda Mejias Glover, Court of Claims serving in Nassau County, the Honorable Wilma Guzman, Bronx Supreme Court Civil Term, the Honorable Ginette Rosado, Bronx Supreme Court Civil Term, the Honorable Joanne Quinones, Court of Claims, serving in Kings County. A special acknowledgement is owed to Court of Appeals Judge Jenny Rivera, who, following a successful 2021 program that she moderated, suggested that we consider doing a reenactment. When it was time to finalize a date, she also suggested we consider Women's History Month because while all the husbands and fathers were away working hard to secure support and plaintiffs from neighboring counties for this case, it was the women like Felicita Mendez who stayed back to handle the rigorous day-to-day farm operations and other work. It is in their honor, in the honor of these mujeres, that I wear my pearls this evening. With this reenactment, you will be transported to 1946. So sit back and enjoy the production, written and produced by a phenomenal team of law students from Columbia and St. John's, with special appreciation for Gisela Alexandria Valdez, a law student at Columbia who never learned about this case, which changed the course of history, despite being from the area where the case was initiated. Giselle, to you I say gracias por tu talento y orgullo. Thank you for your talent and pride. I am certain we will all be enlightened and enriched this evening. We thank you for choosing to be with us tonight. And without further ado, I turn the program over to our esteemed moderators, Judges Mejia, Glover, and Vargas. Thank you and good evening.
Buenas noches, everybody. I am Judge Javier Vargas, and I'm here with my colleague and dear friend, Judge Linda Mejias Glover, both from the Court of Claims. We would like to thank the Latino Judges Association, as well as its president, Walter Rivera, as well as Judge Patria Frias Colon, for in honoring us with setting the stage of the Mendez versus Westminster case. We all are also grateful for the Honorable Analisa Torres, Johnny Barros, and Joan Key, who are going to be acting as judges on this reenactment. And a special thank you to all the incredible students from Columbia and St. John's who worked so hard to, with some artistic, create this powerful reenactment tonight.
Many of you have probably never heard or had the opportunity to study the Mendez case in school or in law school. But this case is critically important, not just because of its profound effects in the Latino community, but because of its impact beyond our community. This case has paved the path leading to desegregation of schools for Japanese, Chinese, and Black Americans throughout California and beyond. Its jurisprudence laid the legal foundation for the landmark case of Brown v. Board of Education, which we all know ended the insidious segregation of Black children in schools throughout the nation.
Let's start with the surrounding law in this country prior to the start of the Mendez lawsuit. The law of the land in the 40s was the separate but equal doctrine, as established by the Supreme Court in the Plessy versus Ferguson case in 1896. This ruling provided legal justification for segregation of the races on trains and buses and public accommodations, hotels, swimming pool, theaters, and schools. Tonight, you will learn how Mendez began a long journey to dismantle this separate but equal doctrine.
And now that we've given you a short historical synopsis, tonight's story begins with the Munamitsus, the Japanese-American family behind the story of Mendez. In 1943, the Munamitsus, like so many other Japanese-American families, were forced to leave their farm in Westminster, California, and be involuntarily relocated to an internment camp in Arizona. Concerned what happened to their land, the Munamitsu family leased their home and Gonzalo and Felicitas Mendez, who were two hardworking California Latino farmers. The home was near the 17th Street Elementary School in Westminster, an elementary school needed for white children.
Westminster School District refused to the Mexican American children. Gonzalo and Felipe led community efforts to change the educational opportunities of the whole county. Gonzalo began working with 4 other Mexican American families to challenge the segregation policy. Together, in 1945, these Mexican American parents lawsuit in federal district court against the districts in Orange County.
While Gonzalo focused on the litigation, Felicitas took charge to continue providing for the family. Her role was crucial in encouraging and providing Gonzalo the time and energy to immerse himself in organizing with the other Mexican American parents to challenge the segregation of their children. Mr. Mendez hired David Marcus, an established Jewish civil rights attorney from Los Angeles, to argue the case.
David Marcus claimed racial discrimination. Mexicans were considered legally white under the precedent of Alvarez versus Lemon Grove district. Instead, Mr. Marcus argued that segregating K-12 based on their nationality or ethnic background violated the Equal Protection Clause of the 14th Amendment of the Constitution. Using an unusual approach, Mr. Marcus introduced social science evidence to support his argument that segregation from white children produced feelings of inferiority among Mexican American children. But what was arguably most effective was the testimony of Sylvia Mendez herself and other Mexican American children who testified in English about how they felt attending down segregated school with all books discarded from the white school.
District Court Judge Paul J. McCormick, a proud Irish American, presided over the suit and issued a decision in favor of the plaintiffs, reasoning primarily that the social, psychological, and pedagogical costs of segregated education were damaging to Mexican American students and undermined their ability to be productive Americans. As you will see in this reenactment, the case went all the way to Circuit Court for the Ninth Circuit in San Francisco. While the case was pending before the Circuit Court, several organizations like the NAACP and the American Citizens League filed amicus briefs. Writing for the NAACP was Thurgood Marshall, who 5 years later used similar reasons with the Supreme Court in Brown v. Board of Education. The Circuit Court of Appeals affirmed Judge McCormick's ruling. And 2 months later, California's then Governor Earl Warren signed a bill ending school segregation in California, making it the first state to officially desegregate its public schools. Interesting, Governor Warren would then go on Chief Justice of the U.S. Supreme Court and author the majority opinion in Brown v. Board of Education.
Our hope that you will see that the Mendez case is important because it was a precedent for Brown versus Board of Education, but also because it is an inspirational example of how members of the Mexican American community asserted themselves for their rights and won. What is even more inspirational is the collaboration among people of different races, religions, ethnicities, and genders who worked towards equality. Indeed, we have a Japanese American who rented their land to a Mexican American and Puerto Rican couple who hired a Jewish attorney to represent them before an Irish American judge, who ruled in favor of Latino children. And on appeal, an African American attorney submitted written arguments before the Court of Appeals, whose white judges declared school segregation unconstitutional in California.
Sorry, that is just unbelievable, the cross-section of people. I'm just awed by that. And as we celebrate Women's History Month, let us shine the spotlight on the bold and courageous women like Felicitas, Sylvia Mendez, her aunt Soledad, who initially took the children to the school, and Aki Munamitsu, who each in their own way made considerable personal sacrifices in order to the effort to accomplish real change being families and local community. So now it's our honor to introduce our guest, Sylvia Mendez. Ms. Mendez was the 9-year-old, half Mexican American, half Puerto Rican girl who was the face of this landmark case. Despite the insidious barriers and obstacles she faced during her early childhood, Ms. Mendez went on, undeterred, to earn a nursing degree and an honorary doctorate from Queens College at CUNY. In recognition of her contributions as a civil rights advocate, she was bestowed the Presidential Medal of Freedom by President Barack Obama in 2011. Could not physically be here with us today. She is here with us by live stream. So now, without further ado, I invite the remarkable Sylvia Mendez to share some remarks with us about the personal impact it has had on her life, her family, and her legacy.
I am so grateful to be here, and thank you for telling the story. I go around the country talking about this case, and people still aren't aware of it.
Ms. Mendez, we'd love to hear your story and what it felt like for you then and what you see today. I know you referenced that after all that work that you did, what you see today is more segregation than before. And also talk to us about what it felt like to receive a medal from President Obama. What was that like?
Okay. First of all, I'll tell you about, I'm going to talk about how I was shocked. First of all, I was so shocked to find out about the de facto segregation. But at least we get rid of legal segregation. Now we have de facto segregation. And that's another thing we're not going to talk about today. But I decided that I would start talking to students not only about the case, but the importance of education and how if my parents could do it, they could buy a cake and win. There's no reason why students are not finishing high school, especially the Latino community where the students are in school. And so that's what my aim is now, to talk to students, and I am doing it constantly, and I continue to do it. And I'm 86 years. I started this 20 years ago, and I'm still going around speaking about the importance of Mendez versus Westminster. When I got that call from the White House that I had won an award, I said thank you and hung up. I didn't realize what the Medal of Freedom was. I had to call a teacher and say, what is the Medal of Freedom? And when the teacher said, oh my gosh, you just won an honor, Sylvia, the biggest honor. Then I was so excited to meet Obama and to go to the White House. And when I got there, I started crying, saying, thank you, God. This is a thank you for my mother and father who fought so much to get this education, to get us integrated, and this is their award. The Medal of Freedom was 13 years after my mother died, and it just was there, giving it to her and my father for the fight that they went through, because they ended up so poor after all this, and nobody would even say gracias, Gonzalo, gracias, felicitas, but there it was, the White House saying gracias for what you have done. So that encouraged me to continue my legacy, to keep on talking about Mendez versus Westminster. Now my friend Aki, from Aki and Sylvia, the Japanese girl that we met. My father fought, but I also have the Japanese in that farm. Aki has a niece called Janice, and Janice has been helping me, and she just wrote the book, The Kindness of Color. And in that book, she tells the story about what was going on with her parents while they were in the internment camp, and what was going on with my family. I gave her my whole story, and she put it in the book. And she also tells the story about the Mendez case, and also the story about the Miso family, their struggle while they were in Postum, Arizona. So we are still friends, Aki and I, and her niece has just been so beautiful. And the name of the book is The Kindness of Color that she wrote.
Thank you, Miss Mendez, those nice, kind words. Now here the reenactment from the students. Students, recollect.
I through my notes for constitutional law. By the way, did anyone catch the name of the case the professor mentioned when we were discussing the Board of Education? I wrote down a quick note, and it sounded like a Spanish surname.
I'm not sure. I think the professor wanted it was related to desegregating schools for Mexican children in California, which was decided before Brown.
Oh, yes. I found it here. It says footnote on page 400. Mendez versus Westminster. A landmark school segregation case that affirmed the right of Mexican American families to send their children to integrated public schools in California. It says it was decided in the 1930s or 1940s.
Oh, fascinating. Thanks for finding it. Add it to my notes, but I really wish we had talked about it more in constitutional law. Great to study a civil rights case with Latino petitioners. Here it reads, the Mendez family.
Right? It was only really brought up in passing when we were talking about the 14th Amendment, and I jotted it down. Now that we know the case, Mendez v. Westminster, I'm going to look more into it. This will be great to learn about as we continue to study the 14th Amendment in class.
Okay, this has been a great session. Let us know if you find anything interesting. I have to head out to a Latinx law students meeting.
Yeah, I have to head out as well, but we'll definitely come back to common law at a later study session.
All right, let me search on Westlaw. Mendez v. Westminster. It was a 1947 federal court case challenging schools and their superintendents that segregated Mexican American students in 4 districts in Orange County, California. Okay, this is all really interesting. I wonder who the Mendez family is. Look into it further. Oh, look, here are pictures of the Mendez family. I wonder how this case all began and why they decided to file suit.
Mira, mamá, look at the beautiful play at the school. They have monkey bar, teeter-totter, swings, a beautiful green lawn. I really want to go to school here. Recess would be so fun.
Sí, mijita, really nice. We are so excited for your brothers to come here. Best teachers in the district, great resources. We are very fortunate that the Miyomitsus have allowed us to lease their land so that we could be in this district. They are wonderful friends and neighbors that have been so kind and generous to us. Let's go to the school office with your dad to enroll you and your brothers at the school.
Good afternoon. My name is Mendez. I'm here to enroll our daughter, Sylvia Mendez, at the 17th Street School. We'd also like to enroll her brothers as well.
Sylvia Mendez, you said?
Yes, sir.
Sir, unfortunately, Sylvia Mendez and her brother do not attend the 17th Street School. We only allow English speakers to attend our school. However, there's a suitable alternative for Sylvia. It's called the Mendez School. And it's also in the Westminster School District. I can direct you to their office to enroll for a child like her. That would be a much better choice. She'll get along with the students better, and she'll have a curriculum that's more suited to her needs. The 17th Street School is just not fit for your children.
Our daughter speaks English very well and is capable of attending school here. She would be happy to speak with you right now. Right, Sylvia?
Yes.
Anything you can do to show that she is capable of attending the 17th Street? Is there perhaps a test you can take or speak with a teacher?
We do not have any language tests on hand today. She and only have to attend the Hoover School. 17th Street School is just not an option for them. The decision is final.
Decision is not done. It's not just to our children. We need to treat them differently than any other child who comes to this office to be enrolled. She's intelligent for her age. She speaks perfect English. She's friendly with all the students. There has to be a way she can attend school here. Either your principal or have the confirmation for the web.
I can take you to the back office to meet our principal if he's available. However, the decision is final.
Mama, I really want to go to school here. The playground is great. I speak English, right? Why won't they let me come to school here?
Mija, the playground is very nice, but let me be clear. This is not why your father and I are challenging your choice. We are fighting for you to attend this school because under God, we are all equal. And you truly belong at that school, just like everybody else in our neighborhood. You deserve the same education as the other students who live here. You and your brothers deserve the best. And your father and I, and I'm confident all other families like us, ever we can to ensure that you have equal opportunity.
This is injustice. Why are they not allowing our children to go to school here? The more people do, the more unethical and racially biased the school's practices appear to be. I spoke with the principal, and he said that our children were entirely unable to attend the school. Yet he could not provide one single reason why they should not attend other than they didn't speak English. This is absurd. Sylvia and her brother speak perfect English. This is a school in a district our children belong. My sister Soledad was able to enroll her children at the school, and ours were denied. I'm sure they were only looking at our last names. To challenge the assumptions, the principal said he would not provide a language test or even find out how capable our children are to attend this school. He said the Hoover School is the only option and the best option for our children. Everybody knows the Hoover School does not provide the same resources or education. There is no playground. I'm sure they keep doing this only for American children in the area because we are of Mexican descent. I noticed the immediate change in the tone of their voice when they read our last name, Mendez. This practice is rooted in discrimination and bias in our Mexican American community. I will now go talk to other Mexican Chicano parents, even our family attorney, to see what can be done to fix this. I will go talk to the school board, the superintendent, our children, and all Mexican and Chicano children in the area deserve to attend this school.
After I delved into the struggles faced by the Mendez family leading up to the case, I knew I wanted to learn more and share this history with my study group. I researched how the case was initially filed and the arguments on both sides of the segregation issue. 4 other Mexican fathers joined Gonzalo in challenging the segregated practice in the U.S. District Court for the Southern District of California, Central Division. They were all represented by attorney David Marcus. On March 2nd, 1945, Marcus filed a class action in the U.S. District Court on behalf of the named families and 5,000 similarly situated people of Mexican and Latin descent who resided in the Orange County area. The complaint was filed against Garden Grove Elementary School District, Westminster School District, Santa Ana City Schools, and El Modeno School District in Orange County, California. The petition alleged for several years the district acted with a common scheme to exclude children of Mexican or Latin descent from attending, using, enjoying, and receiving the benefits of the education and recreation facilities of certain schools within the respective districts. It further alleged that these children had been segregated and required to attend certain schools that were reserved exclusively for children of Mexican and Latin descent, while other schools with better resources were reserved exclusively for white children. There were amicus briefs filed at the district court level, including one by the National Lawyers Guild and the American Civil Liberties Union. Looking more closely at the case, I learned more about the arguments made in the district court and the district court's post-trial decision.
Members of the gang, May it please the court. My name is David Marcus, and I represent the main petitioners in the case who have been negatively impacted by their class and categorical segregation from certain public schools in the Westminster, Garden Grove, and El Modeno school districts, as well as the Santa Ana City Schools. We bring this suit to challenge the constitutionality of school district rules that American children of descent must be segregated in the public school system. These children have been arbitrarily assigned in schools reserved for and attended solely and exclusively by children of Mexican and Latin descent, while other schools in the same district were reserved solely and exclusively for white children. The facts show that respondents have enacted these laws in their respective districts without a rational basis. The relief we seek is a declaration that these violate federal law. We demand that the districts be required to desegregate.
Counsel, is it your argument that the school districts have a written policy in place segregating children of Mexican and Latin?
In place. However, in practice, the facts prove otherwise. In fact, for several years, these school districts have executed plans that exclude children of Mexican or Latin descent from attending certain schools within their school district. They have forced children of Mexican and Latin descent to attend school districts that were reserved only for students of Mexican or Latin descent. These children were barred from attending schools for white children. We represent the father of children of Mexican or Latin descent who have been excluded from attending schools. Their children were forced and compelled to attend schools in respective districts reserved for and attended solely by children of Mexican and Latin descent. Yet their children were equally qualified in schools for white students within their respective districts.
What relief do you seek?
Your Honor, we ask support for the following. First, that these rules, regulations, or customs be held to be unconstitutional. Second, that the respondents be permanently compelled to admit petitioners and all persons of Mexican and Latin descent to the use of schools in their respective districts. And third, respondents be enjoined and restrained from in any way excluding petitioners from the schools within their respective districts.
It seems more like a state law claim. Does the court even have jurisdiction to hear this case?
Your Honor, this court does have jurisdiction over this. We do not claim that the right to attend public schools, which is a state law right, is violated. In this case, the federal right to equal protection of the state's laws has been infringed by the district's discriminatory and arbitrary. Here, there was a concerted and design of class discrimination against persons of Mexican and Latin descent of elementary school age by the respondents in the conduct and operation of public schools. These are a clear violation of their right to attend schools in their district. And the immunity they assert is to be free as other children, not Mexican, regulations based on no other ground aside from their ancestry. Segregation of children here undoubtedly violates the protection clause of the 14th Amendment. The respondents' answers even admitted that Mexican children were segregated from other children. Thus, the respondents in this case have the burden to prove that this segregation does not violate the Constitution. It's argued that Mexican children are dirty, that they don't speak English, that they are inferior to other children, and that they don't have the mental capability of white children. These arguments are unjust and they are blatantly false. Many Mexican children speak English perfectly. They prove their intelligence in schools and they are not dirty. Thus, it is right for the parents of these children to call for justice. Their children have had their federal constitutional rights violated without any justification or reason. The respondents claim that this segregation is for Mexican children's own benefit. Mr. Kent, superintendent of Garden Grove Schools, testified that the Hoover School serves Spanish-speaking students as they have a definitive bilingual handicap. He stated that students were sent to these schools because of linguistic difficulties, not because of their Mexican ancestry. He stated that these Mexican students needed to be taught mannerisms and cleanliness through a process of Americanization. The children need to know Mother Goose rhymes and tales of American heroes spoken English. Now, he claimed that if they were met, the students would be allowed to attend the school. Mr. Kent was incorrect. Once again, the facts prove otherwise. We have testimony from various families that their children met these standards, that they spoke English perfectly, that they lived in the correct school districts, and yet they were still denied from attending the schools because they were Mexican. The superintendent of schools in the Santa Ana City School District said instead, they classify these children by looking at their names. Thus, constitutional violations are sustained by undisputed proof of usage and custom. In every district, the segregation was complete, and except in a very few circumstances, no Mexican children had attended a school other than where no enrolled. Some Mexicans had all of the requisite qualifications, and the only hang-up for those children was their ancestry, and thus they were denied. It will be irrational to the cultural background of an American child of Mexican ancestry requires schooling in another institution based on assumed deficiency in familiarity of Mother Goose rhymes. Ability in a foreign language is a strength, not a handicap. Under our constitutional structure, all persons are entitled to equal protection of the law. The school boards have failed these children. Here, separate is not equal. Simply look at the evidence of the differences, sources, and outcomes of these schools reserved for children of Mexican or Latin descent as compared to schools reserved solely for white. The rules and regulations of these school boards were constructed and applied to violate the Equal Protection Clause of the 14th Amendment. And they have denied to the pupils of Mexican ancestry the privileges and immunities accorded to all other American students. This court's decision is of tremendous importance. We cannot fail these students. Therefore, we ask this court to find the segregation unconstitutional. Thank you.
Thank you, Counselor. Respondents, you may proceed.
Good evening, Your Honors, and may it please the court. My name is Joel Ogle, and I represent the respondents in this case, Westminster School District of Orange County, Garden Grove, and El Molino School Districts, and the Santa Ana City Schools, and the local superintendents of said school districts. First, we'd like to address the issue of jurisdiction. Here, the court lacks jurisdiction over the subject matter because there is no federal question involved. Education is exclusively a state matter. This is not a suit authorized to be brought by any person to redress the deprivation under color of any law, ordinance, statute, regulation, custom, or usage of any right of privilege or immunities afforded by the Constitution. In Plessy v. Ferguson, the Supreme Court held that the Constitution does not guarantee social equality. Section 1 of the 14th Amendment allows for citizens to be given equal opportunities and facilities for an education at a public place. Respondents provide. Respondents have not denied or impinged upon any right guaranteed to the students here by Section 1 of the 14th Amendment. Westminster School District maintains 2 elementary schools. These schools are a district where many families of Mexican descent live. These families speak the Spanish language in their homes, and a large number of the children are unfamiliar with the English language when they begin school. Thus, in order to ensure efficient instruction for these pupils, the Westminster School District instructs these students in different school locations from students who are familiar with the English language. The different school location is for the student's benefit. The Board of Trustees of this district states it is in the best interest of both pupils of Mexican descent and English-speaking pupils that these groups be educated separately as they begin their elementary education. So the board established a rule requiring Mexican students who were unfamiliar with the English language to attend a school set apart for a specific purpose and benefit. The students only had to attend school until they became proficient in the English language. The school for students of Mexican descent is furnished and supported with all of the same facilities and instruction as those school English-speaking students in the district, in conformance with this country's precedent, separate but equal precedent from Plessy v. Ferguson. Additionally, the teachers who instruct these students have the same qualifications and are paid the same. The respondents do not have a rule, regulation, or custom which would deny the admission of a student of Mexican descent to a school within the district solely on the basis of their descent. Thus, we request that the action be dismissed. Respondents have judgment for their costs. Thank you.
Thank you, Counselor. I, the Honorable Paul John McCoy, United States District Court for the Southern District of California, will now deliver the decision of the District Court. I hereby adjudge and decree that this action is a representative class action on behalf of the Mendez, Guzman, Palomino, Estrada, and Ramirez families, and of all similarly situated persons of Latin and Mexican descent. The action has been brought before me. It is conceded by all parties that there is no question of race discrimination in this action. It is, however, admitted that segregation per se is practiced in the school districts, as the Spanish-speaking are required to attend schools designated by the boards and apart from English-speaking pupils until they acquire some proficiency in the English language. The ultimate question for this court is whether such official of the defendant school districts operates to deprive the so-called non-English speaking students of Mexican ancestry the equal protection of the laws. Education is not absolutely or exclusively a state matter. A violation by a state of a personal right or privilege protected by the 14th Amendment, such as the state's duty to provide for the education of its residents, justifies intervention by this court. We hold today that the equal protection of the laws pertaining to the public school system in California is not provided by furnishing in separate schools the same facilities, textbooks, and courses of instruction to children of Mexican ancestry that are available to other public school children. A paramount requisite in the system of public education is social equality. Spanish-speaking children are unable to learn English if they are not given any exposure to English. Commingling the entire student body instead develops a cultural attitude among children essential for the perpetuation of American ideals. Segregation in these school districts fosters antagonisms in children and inferiority among them where none exists. The regulations, customs, usages, and practices of defendants in segregating persons and pupils of Latin and Mexican descent in separate schools manifests a clear purpose to arbitrarily discriminate against these students and to deny them the equal protection of the laws. Accordingly, it is ordered, adjudged, and decreed that these practices are arbitrary and discriminatory and in violation of constitutes schools in one's own district must be open to all children, regardless of lineage and descent. Therefore, it is further ordered that the defendants are permanently banned and enjoined from segregating pupils of Mexican descent in the elementary schools of the defendant school districts in the city of Santa Ana and elsewhere in Orange County and in the state of California.
This decision was a historic for the Mendez family and all of the students of Mexican descent in the Orange area. However, the Westminster School of Orange County and the superintendents of the various districts were dissatisfied with the outcome. They ultimately appealed the decision to the Circuit Court of Appeals.
You may proceed.
Good evening, Your Honors, and may it please the court. My name is Joel Ogle, and I represent the appellants. Westminster School District, Garden Grove Elementary School District, and Modeno School District, Santa Ana City Schools, and the local trustees and superintendents of said school districts. Appellants assign 2 points of error to the district court's denial of our motion to dismiss. First, district court lacks subject matter jurisdiction of this action, and that appellees have failed to state a claim upon which relief can be granted. The district court determined that the establishment of separate school systems for pupils of Mexican or Latin descent and pupils of white or Anglo-Saxon descent raised a substantial federal question that brought this case within its jurisdiction. It based this conclusion on the premise that the operation of separate school systems violated privileges or immunities under the federal Constitution, particularly the 14th Amendment right to the equal protection of the laws. Appellants contend that this premise was itself in error. The Supreme Court held in Cummings v. Richmond Board of Education that public education funded by state taxes is really a matter of state concern. Furthermore, as appellees dispute, appellants have provided all pupils within the institutions with equal facilities and equal instruction. And Supreme Court precedent holds that providing separate yet equal facilities to distinct groups does not violate the equal of the laws. There's no allegation in the petition the schools reserved for and attended by children of Mexican descent are any different from other schools maintained by appellants. There is no claim that the tech facilities, physical conveniences, efficiency of the teachers, or class curricula are different from those in any other schools maintained by appellants. There is no allegation that the students receive fewer opportunities as a result of attending these schools. There is no federal right at issue to provide a federal court with subject matter, and the district court erred in finding it had jurisdiction to hear this case. Alternative, appellants contend that the actions, rules, or regulations complained of were not made pursuant to or under color of the law of the state of California, and thus appellees cannot state a claim for a violation of their constitutional rights. The point orders that no state shall deny the person within its jurisdiction the equal protection of the laws. Appellees argue that appellants, as agents of the government, violated this right by establishing separate schools for the education of pupils of Mexican or Latin descent, separate and apart from schools maintained for other pupils. However, the petition did not allege that this separation or any conduct was sanctioned by the State Board of Education or any law of the state of California, nor could it. Section 2204 of the California Education Code provides that the governing board of school district shall prescribe and enforce rules not in with law or with the rules prescribed by the State Board of Education. The district court stipulated to the fact that appellants' individual agents clearly ran afoul of this provision, finding the method of public school administration is contrary to the general requirements of the laws of the state of California. That court concluded that the segregation at issue indicates an official school policy that is antagonistic in principle and action to the education. Appellants argue not only that no such official existed, but that such a policy could not exist given the status of school districts as mere administrative agencies of the state. The individual agents did not and could not act as agents of the state in organizing the systems of separate schools, as the officers at issue in this case could not have claimed to act statutory authority, there is no state action, and appellees cannot make out a claim under the Equal Protection Clause. For the foregoing reasons, we submit that the petition, opinions, and findings conclusively show that there is no federal question involved in this action, that the district court erred in denying appellant's motion to dismiss, and that the judgment of the district court first. Thank you.
Thank you, Cal.
As in the district court proceedings, various briefs in support of the Mendez family were filed, including briefs by the NAACP, American Jewish Congress, ACLU, the Japanese American Citizens League, and the California Attorney General. Marshal and co-counsel Robert Carter, who was later appointed as a federal judge in the District of New York, and Lord Miller assisted in filing the amicus brief on behalf of the NAACP. As Thurgood Marshall also argued Brown v. Board of Education, I became particularly interested in learning more about the arguments presented in the brief for Mendez. I decided to research his role some more.
You may be heard.
The Honorable Judges of the United States Circuit Court of Appeals for the Ninth Circuit. My name is Thurgood Marshall. And I'm here on behalf of the National Association for the Advancement of Colored People. I respectfully move that the court permit us to file this brief amicus curiae. Gonzalo Mendez, on behalf of 5,000 people similarly situated of Mexican and Latin descent, filed a class action lawsuit. The complaint alleges a concerted policy designed to discriminate against elementary school students of Mexican and Latin descent by the defendant school agencies, resulting in the denial of equal protection of the laws to petitioners and the class of persons whom they represent. Here, the respective defendant agencies have maintained a policy, custom, and usage of excluding children of Mexican descent from attending, using, and enjoying the benefits of education in certain schools in their respective school districts. They require these students to attend schools solely for students of Mexican descent. To be clear, this exclusion is the basis of race. Lord, while it was stipulated that there are no inequalities between the school for those of Mexican origin versus those for white students, the court below considered a separation a violation of equal protection, which is guaranteed by the United States Constitution. Judge McCormick was correct in that conclusion. The 14th Amendment was designed to benefit newly freed Black individuals, but its protections has been extended to all persons. By its adoption, Congress intended to create and assure full citizenship rights, privileges, and immunities for all Americans, including people just like Gonzalo Mendez's little girl. Although the United States Supreme Court has limited the scope of the 14th Amendment more narrowly than its framers intended, the decision has almost uniformly considered classifications and discrimination on the basis of race as contrary to the law. We saw this in Ex parte, and we saw this again in Strouder versus West Virginia. Time and again, the acts of state agencies which have established distinctions on racial lines have been struck down as violations of the 14th Amendment. Even our national government is prohibited from making the basis of race and color as the requirements of due process. Since the Civil War, a body of constitutional law telling us that our national and state governments are prohibited from making distinctions and classifications on the basis of race, color, or national origin. The equality demanded by the Constitution and laws of the United States cannot be realized under a system of segregation. Discrimination is the direct result of segregation. Racial segregation in education is a weapon to keep minority citizens in a status inferior to white citizens. If one particular segregated school from one particular area provides equal facilities as its parts, despite segregation, it is an exception to the rule. We cannot pretend like it is a model that is being replicated nationally. This cannot be pointed to as a justification for segregation. The fact is that where segregation is commonplace, it is used to enforce a hierarchy among the races. The educational record and standards in California are high, a model for many states in the country. However, if the principle of segregation in California remains, those standards will fall, especially as the metrics look at the success and achievement of students of Mexican and Latin descent. The records and statistics of these states where segregation is a part of public educational policy show that this policy creates a severe educational inequality. The unjust result of segregation is applicable to any group subjected to the practices of racial segregation. So this includes Black, this includes Mexican, and this includes Japanese students. The system deprives the students of educational opportunities, and it deprives them of future professional endeavors. This practices racism by teaching white children to regard marginalized groups as different and apart. Our national government has signed various treaties with Latin American nations to prevent discrimination on the basis of racial or religious reasons. As an example, the Act of Chapultepec in Mexico City provides that we treat our Pan-American neighbors with equal dignity as our European allies. Last I saw, we still practice the good neighbor policy in our foreign relations under administration. It is essential that the United States citizens of Latin American and Mexican origin are treated with the equality which we grant to Mexico and Latin American transnationals in our international policy. Why would our own citizens any differently? So in closing, segregation on a racial basis in the public school is arbitrary. It is unreasonable. It is discriminatory, which it's a class of discrimination that should be forbidden under our laws. There are no decisions of the United States Supreme Court that prevent this court from declaring the segregation in question as unconstitutional. The other side points to Plessy v. Ferguson, and while it was accepted, the separate but equal doctrine was limited to the applications to carrier accommodations. It assumed that the application of Plessy validates this theory of segregation in public schools. However, in no case has this question been determined. There is no law that supports this. We've developed a theory of government which finds distinctions on racial grounds invalid to our best interests and contrary to our laws. Thereby, the decision of the lower court should be affirmed.
The petition contains allegations of the following: a number of minors for themselves and for 5,000 others as to whom the allegations of the complaint apply, students of Mexican descent who attend the public schools of the state of California in Orange County filed a petition by their fathers for relief against trustees, superintendents of several school districts, and the superintendent, the secretary, and the members of a city board of education. A common plan by the school officials has been adopted and practiced, and common rules and regulations have been adopted, put into effect, whereby petitioners and all others of Mexican and Latin descent are barred, precluded, and denied from attending and using the benefits of education provided to other children. To this petition, the school officials respond by motion to dismiss for lack of federal court jurisdiction. because this is to be brought to address the deprivation of any privilege or immunity secured by the equal rights, protections of the United States laws. A judgment was entered that all segregation was and is arbitrary and discriminating and in violation of the rights guaranteed by the Constitution. Appellants appealed that judgment and argued that we should reverse based on the authority of segregation cases such as Plessy versus Ferguson, in which the Supreme Court upheld the right of states to segregate citizens, provided that equal facilities be provided to all.
We hold that the appellant actively segregated school children for several years, contrary to California state law. The petitioners are citizens of the United States, are of good moral habits, free from any disease or disability, and are fully qualified to attend and use the public school facilities. The amicus curiae briefs pose the question of segregation. We leave this issue to the state legislature. However, the segregation is without legislative support. Segregation of school children of Mexican descent violates the laws of the state of California and violates the 14th Amendment of the United States Constitution by depriving petitioners of liberty and property without due process of law and depriving them of the equal protection of the laws. The lower court judgment is affirmed.
These facts I have told you are the powerful story of Mendez v. Westminster. From my research, I have now realized that the door to our education as Latinx students was truly opened by the Mendez family, especially for myself as a Mexican-American student from Southern California. This case was the Brown v. Board of Education for Mexican-Americans in California. 2 months later, after the decision in this case, California's Governor, Earl Warren, signed a bill ending school segregation in California, making it the first state to officially desegregate its public schools. Advocates like Thurgood Marshall were inspired upon this case and drew upon those arguments for the arguments in Brown v. Board of Education. And it was then Chief Justice Earl Warren who delivered the unanimous ruling in Brown.
You know, it's really great that we now know this case and its history. Their story is so inspiring, especially considering our role as Latinx law students. Thank you for sharing it with us. What happened to the Mendez family after the case?
Sylvia Mendez worked for more than 30 years at the Los Angeles University of Southern California Medical Center. Various schools in California have been named after the Mendez family. They have even been honored in a U.S. postage stamp. Most importantly, the Mendez family has sought to ensure that this case lives in classrooms by spreading awareness about such a landmark decision. As this fight for justice and equality is not just about Mexican-American students, it is for all marginalized individuals who have opened the door for students to have access to education. It's time that we learn about this history as future Latinx lawyers.
Well, I'm honestly so grateful for their work. We have to help spread and do our part to spread awareness about this case. Now let's go share it with the rest of the law school students.
So before we continue with our incredible program, I would like to get some feedback from our justices. How was this impactful to you in terms of what happened at the district court level and what happened at the appellate level?
Well, it was the first time I heard of the case, I admit. And so for me, it was very eye-opening. I would also add that the video brought it full circle because this represents what was done then with respect to the injustice, the segregation. The video, Mendez pointed out that the segregation continues. So now you have to call upon the young Latinx students to find creative to address the segregation that actually still very much exists. And many of us could attest to that, I'm sure. And many of us were lucky not to be placed in those inferior classrooms. We got the benefit of being able to go to school with the white children. I can speak for myself. That's what happened. I was bused. But the segregation truly still does exist. And so up to this next generation to be creative and to approach the new problems. So I think this is really wonderful. Thank you.
Thank you so much for Betsy Battles, who is our justice in the appellate division, second department, and a justice of her esteem. Not having heard about this case, Mendez Westminster, as many of us haven't, I think is why it was so important for the Latino Judges Association to ensure that we take this case, share it with everyone, our high school students and beyond, our college students. Go back to your alma maters and create this. For me, having chaired this committee for the second time, the first one in 2021 when we had the documentary by Sandra Roby, it was just so inspirational to me, having seen and heard the young Sylvia Mendez at the time, who was maybe 12 or 13 years old, have her be able to speak to us live in 2021 and again now in 2023 is just so incredible to me, so moving. And the love that these families had for each other, especially the Japanese family who was unfortunately sent to these internment camps. That was the reason we're able to have a Mendez Westminster. And it is so incredible to me because as Latinos, and I'm very proud to be Latina, we don't hear about these stories of our ancestors, right? Because we live in a place that is so black and white. And it is so incredible that in 2023, we still have so many young people like Giselle from California who didn't know about this. So she was a student at Columbia Law School and heard about it through our partnership. So it is so incredible to me, and I'm just in awe. We're in the Southern District of New York, the courthouse for our state. And thankfully, we have federal district court judge, the Honorable Ana Flores, who made sure that we were able to spell this case out and share it with all of you in her house. And if we can just hear what was it for you, Judge Torres, in terms of this before we turn it back to our students.
When I reflect about this case, it reminds me that our struggles are so very, very old. Of course, Latinos have been in the United States, well, before it was the United States. And we have had Afro-Latinos here since the 1600s. So while the Mendez
able to get redress, well, that is a function of progress at that moment. Before then, a person, circumstance, and when I say that circumstance, I mean exclusion, may not have been able to walk into the courthouse. So how lucky we are to be able to observe that progress, but how unfortunate, as Judge Barros points out, that we find ourselves still battling exclusion.
Thank you for those words. And Judge Quiñones, I would like from you to address the district court, which heard for 2 weeks. This case went on for 2 weeks in a trial where we heard really troubling positions by the superintendents, by the principals of these Anglo-Saxon schools. What was your impression from having to and declare the decision that was declared back in 1946 by Justice McCormick?
You know how I do not like to go off script, but because Patria just asked me a question, I'm going to respond to said question. So I have to say that I was actually familiar with the Mendez v. Westminster before we did this the first time, and obviously before we did it the second time. In fact, I have the stamps that you all referred to, and I even have a cool pin that my friend Justice Jeanette Rosado got for me when we did it the first time. And I read the case once again in preparation for today's program. And I have to say, like, you know, I'm a court of claim, I'm just playing the role of a district court judge here because, you know, I was trying to get my debut on and, you know, maybe get discovered and whatnot. But reading that decision, right, like delivering that decision was so impactful to me. I was like, I mean, I really got into it. Even when we did the rehearsal, earlier this week, it just hit me, right, how Sylvia and her parents when this decision came down. And today, you know, like we couldn't help ourselves. District court judges are supposed to be like very, you know, here's our decision. And we were like, yay, you know, that's how, I mean, it just brought it home to me. And I was happy to be here, part of this group, part of these students doing this reenactment. It was just, I can't even put into words how much I felt when I delivered that decision. I wish I had been there in real life, but go ahead.
Thank you so much for we proceed to our students. I'd like to hear from our moderators because they've been working so hard in front and behind the scenes to ensure the flow of the program. And it was important for us to see a reenactment by our young people from St. John's Law School and from Columbia Law School. What is your impression? Yes, yes. What was your impression, and we'll start with Judge Vargas and then we'll hear from Judge Mejias Glover, your impression from the students' perspective in arguing before the judges here tonight?
Well, thank you for this, Judge Frias Colon. I think that the most important thing that I got from the case and from the presentation from the students is, like I mentioned before, about the collaboration among the races, among the religions, among the ethnicities. I have to, isn't that what it's all about? For us to get together, regardless of how we perceive ourselves, and to get us to get the liberty and the justice and the happiness there. We have to get together to do that. I think that that's the most important thing that I learned from the case. I'd like to mention also that the Munemitsu's family, not only they provided to the Mendezes the ability to continue supporting their family through these difficult times, but if the Mendez family didn't take the Munemitsu's farm, their farm was confiscated by the U.S. government. So they know that it was so many things that the Mendez family did to not only to Orange County, but the U.S. with their by the actions.
Incredible. Yes. Thank you so much for that.
Thank you. We weren't aware that we were going to be asked questions, but he said, truly, truly, I am amazed by what these law students have done. Truly. I wasn't aware of West Law School. I did come to learn of it later in life. I've done some studies of Latino jurisprudence that affected Latinos in the United States somewhat recently, but I never could have done what you guys have done when I was at law school. And, you know, I'm just so proud of my alma mater, Columbia Law School. We have our president, alumni president here, Rudy Carminati. So impressed with your delivery. You know, the lawyers that were giving their oral argument, I really felt like you were prepared to be before the Supreme Court of the United States. I'm listening to you, not I'm putting myself as a justice of the Supreme Court, but I'm listening to you and the confidence, the delivery, just, you know, you really owned it, and it was fantastic to see. And I think it's wonderful that this early in your career that you are aware of this case, that you are aware that there is students that, you know, that is overlooked. And this particular case, though it's not Brown v. Board really wouldn't be but for this case. So it's important to, you know contributions. Maybe they're not all getting the spotlight, you know, and not part of our culture. But, you know, we're the backbone of this country in so many ways. And this is just another way that shows you that truly the Latino contribution to this country is beyond just, you know, the economics, I mean, the great food, right? We have amazing intellectuals. We have hardworking people who give a lot to this country. And so I'm awed by you guys. Dean Saavedra, you know, I think that you're the best.
Thank you so much.
Let's do it and go share it. And let's be sure to shade all future lawyers too. They should know this history before they enter law school as practicing attorneys. We are so grateful to the Mendez family and for the work that they have done to spread awareness about this case. But our duty to spread awareness about this case too, and carry the torch and pass along the information of Mendez v. Westminster to the next generation of Latinx law students. We must continue to shine a light on such a powerfully impactful case.
Okay, so again, we want to thank this wonderful, give them another round of applause. To our deans, to our committee, thank you so much. And now we'd like to open it up for some question and answer here. The question was, what was the motivation or the impetus for this particular reenactment and doing presenting Westminster tonight?
I can that since I spearheaded both the 2021 program and the 2023 program with the support of the Latino Judges Association. It was really simple. I came across this case, as many of you, attending an event in the evening, and I started myself teaching in the school at St. John's, where I was an adjunct. And I said, at that point, it was the 74th anniversary of the case. And I really wanted to celebrate the 75th anniversary of the case because we close to so much the 50th anniversary of the Brown versus Board of Ed case, which was notable for our in our history. And so I said we have to encourage and embrace what we've done as well. And so I connected with Jose Perez from Latino Justice, formerly Puerto Rican Legal Defense and Education Fund, who himself had worked with Sandra Roby, who wrote and created the documentary, which I'd encourage everyone to view. Is on our website that has been sent to everyone. If you go to the 2021 program, the entire documentary is there for you to watch. And so that really was, I wanted to share, and I was almost inspired by the fact that Sylvia Mendez was there, really trailblazing in California. She took a trip to New York, and if she can do it, to keep the promise that she made to her mom, Felicita, I said, we have a duty to ensure that that story continued to be told. So I wish that tonight everyone takes this and makes sure that we keep that promise to Felicita and to Sylvia, because we're not going to have Sylvia forever. And so that's why when St. John's Law School and when Columbia Law School stepped up to do this without extra credit, simply from the love, I was just in awe. So thank you so much for that question.
Okay, the question was, what is the lasting impact of the Mendez v. Westminster case?
I mean, certainly for me, the lasting impact was that the then governor of California, who was Earl Warren, he had a decision to make after the district court, after the circuit came down with their decision to uphold the family's position. He could have taken it on up to the Supreme Court of the United States or not, and he chose not to. And I think that was on purpose. We have to give credit where it's due. And when he made that decision, and then later became the justice of the Supreme Court, the justice, the head guy, when the versus Board of Education case was argued, that impact, we're feeling it and we're feeling it now, right? That's how long lasting it was. So the players coming together, Thurgood Marshall, the amicus brief he provided, and then becoming himself a justice, and certainly before that, arguing before Earl Warren as the justice in that case. I think everything aligned, and because of that the Mendez family did in that case and did not, even after they thought they had such a win from the lower court, then they had to fight again for the appeals court in the federal system. That is the long-lasting impression. The fact that we have Sylvia Mendez with us today, all the way from California, to tell us about this experience in 23 from something that happened in 1946, that is long-lasting. So thank you so much for that question.
So this question is for Mrs. Mendez, if we can unmute her. One of the participants who's watching online had a question and wanted to know how you felt walking into school after the circuit decision came.
I was so excited. My gosh, because all this time I thought they were fighting for me to go to a school with a playground, because we didn't have a playground in the Mexican school. So once I could go to a swing and monkey bars and teeter-totters. I was just so excited. I was only 8 years old when we started and 9 years old when we finally won. And all this time I'm thinking we're going to have a school with a playground.
Can you tell us again, and because I know you went to the Hoover School, the Mexican-American children. Give us a little story from the experience you had at that versus what you saw in the Anglo school.
In the Mexican school, all dirt, no playground, a fence wired with electricity to keep the cows from going into the playground that one of our students grabbed and couldn't let go. The teacher had to go and tell her not to tell him to get rid of the electricity so the student could let go. The school was horrible. Every day the bus would come and drop us off in front of the white school, and Gonzalo Jeronimo and I would have to walk into the Mexican school about, I don't know how many blocks, 6, 7 blocks into the barrio. And I would say, my parents are fighting so I can go to that white, beautiful school with a playground. And that's what I was always thinking about, the playground. when I went to the white school, and this little boy approached me and said, "Ooh, you're Mexican, you don't belong here." And I started crying and crying. And I go and tell mother, I'm going back. They don't want me here. That's when she told me, "Sylvia, don't you know what we were fighting?" "Yes, to go to that beautiful school." She said, "No. We were fighting because we're under God, we're all equal. And we all deserve to have an equal education. And yes, you're going to school." I went back to school and discovered when I was 9 years old already that everybody in this wonderful country of ours, the United States of America, is not prejudiced, is not a bigot, and I had a wonderful time in the integrated school. That's what I discovered.
Thank you so much for sharing that.
Thank you.
Not only as aspiring lawyers and practicing lawyers, but as people, are there any other cases that have not been publicized that have been just hugely impactful that we should know about? That you can think, this is the question the panel.
What a great question. And we have actually Jose Perez, audience. And tell us a little bit, he shared with me today that very question. There was an article in a Latino medium online paper talking about all the cases, well, they referenced cases, one of which, incredibly, was Mendez. Another one was,
That's in back.
there was two more. They'll come to me. But that very question, there are many. There are many. I think our responsibility, certainly now that I've graduated law school and I'm for quite some time, is to go back to my alma mater and insist that those cases be referenced. This Mendez should be front and center in constitutional law, period. Because
Absolutely.
the value that this case has and the multiple things that we can talk about this, it's not just about the legality of what happened. It's the human factor of what happened. And so to me, it's so that our elementary and high school students learn about it and see how people from race get together and address a situation. And strength in numbers is so real. And so it's just an incredible thing. And I really encourage everyone to go in and do some more research, because you will see the numbers that are out there that have changed the course of history in the criminal world, obviously in the civil world, and in our civil rights arena. Latinos, Cesar Chavez is somebody that comes to mind. There are so many cases involving the work that and laborers and experiencing today. So that was a great question. Thank you for that.
I would just also add that it's important to study the strategy, the legal strategy, how the cases were approached, because the only way you have something different is by trying something, because the old stuff doesn't work, right? It stops working. Somehow it gets reconfigured and now you have to start again. So you have to study what works, what doesn't, and just be creative. Because, the foundation of this case was about justice. And you speak about justice, it's very hard for the court to say and not to do it. It's hard to do that. So I think that's really important as attorneys, to be creative.
Hello, hi, everyone going. I have a question about how do you think the expanding of how educational wise within the South, how these court cases are being taught, do you think, is there any way we could change it within our modern age of expanding it to the South and, educating young students who are taught that history is written by the winners, and in this case, we're learning more about the civil rights cases within our time in the East Coast? Or how do you believe we could expand it?
What a great question. I can share some of my thoughts on it. For me, when I learned about the Mendez case, and I didn't learn it in law school, I taught it, I took my network and expanded it. So I need to do is we cannot sit by and wait for someone to do it for us. That's a lesson I think we've all learned in our work, in our professions. And I think that if we see something to be repaired, if we want to see more of our cases, more of our stories being told, we have to tell them. And we cannot wait for an invitation for that. Certainly, Gonzalo cannot wait to be invited, for their daughter to be invited into that school. They did the incredible, and that's what we need to do. We cannot wait for others to do the work that we know we have to be capable of doing, and that's within our network and an ability to do. So for me now, as a judge, County Supreme Court, I have a wide of networks that are accessible to me. I make sure that I am active with our Latino Judges Association, with our American Judges Association, with our judicial friends. And it's important that you in your circles get out there among your peers, sure that your schools are teaching you the story that you need to know about. Right? We got to take that responsibility. So I share that, and I'll leave you with that.
Let's hear from Jose Perez, Justice.
Here presenting this program, educating our young people about the Mendez v. Westminster. It's a pleasure to see Ms. Mendez again on the street, long distance. But again, the Latino Judges Association, and our committee, I submitted members here. You should all know they were meeting regularly for the past 2 years. Early Friday morning, Judge Frias Colon runs a tight ship. Putting this program together. I commend there the question about like other cases. Mendez v. Westminster, Judge Frias Colon mentioned that you have to watch all the children para todos los niños. That talks about the racism, segregation going on in California in the 1940s. Again, remember the Mexicans were only permitted to go to the pool on Sunday, and then be emptied and then disinfected before the white folks could come back in and use it, right? That was the racism and segregation that existed then. We heard today, today. We have to do that. The young man, his question, what can we do? Don't accept it. Step up, have a voice. And even when the Supreme Court says no, like in Plessy v. Ferguson, separate but equal is okay, it wasn't. Come back and reverse that decision later on, right? The other cases you want to learn about, Hernandez v. Texas, out of Texas, Mexican Americans were prohibited from sitting on juries. And again, they weren't right. There's a wonderful documentary called A Class Apart. Also that tells. Sorry, I think Judge Frias Colon is going to love it. The last case I have to make a mention is Aspida versus the Board of Education here in New York City. It's a case that American Legal Defense and Education Fund, my brought back in 1972 to fight the denial of bilingual education to our students in our public schools here in New York City. So again, I just wanted to my question. Why isn't this case taught in our law schools and constitutional law classes? Again, I like the scenario of the enactment that the law school students were looking. Oh, there's a footnote on page 400 of the decision. Why isn't these cases, why isn't our contribution to jurisprudence, Latino civil rights in this country publicized?
That is a great and very lengthy discussion that is to be had.
Just to echo what the gentleman said, the case you really need to study is Hernandez v. Texas. I've done programs on Hernandez v. Texas. I did it at Columbia just for something like that. And I'm happy to do it for you as well. Because it's the history really of Mexican Americans, and that was the case that gave people other than African Americans protections under the 14th prior to not recognized under the U.S. Constitution. This is a very important case. Hernandez is a very important case, and that has all. The reason why we don't know it is because we don't tell our own stories. It's really dependent upon us. No professor, no law school, no one's going to tell you anything except yourself. And I would say to everyone, whether you're from California, Texas, New York, Florida, we all came here in the same way, more or less. and we're all together.
Thank you so much.
Thank you. Thank you so much for the questions.
I just add one thing, just to bring it more recent, and then this is a case Latino Justice was in, the Vargas case. Am I right? Involving the dreamer, the child of Mexican descent who was a dreamer. College, went through law school, graduated, and was being barred from getting a license to practice because he was not a documented individual. And that case was brought by Latino Justice for the Second Department. And that's why I mentioned creative thinking, because we had 22 judges and we sat there and we said, no, we're not going to let this kid in. And the federal government, the law was prohibiting it. And somebody got creative and they said, you know what? The state decides who gets licensed. And New York, that's the Second Department, decides. And so we decided, yes, se puede. And we did that with